The heavy redaction in the initial batch of files, the DOJ says it erred on the side of, quote, over-redaction to protect victims of Epstein.
When the Epstein court documents were finally unsealed, millions of people expected bombshell revelations.
Overnight, the Justice Department released hundreds more heavily redacted pages of material it had gathered on convicted sex offender Jeffrey Epstein.
Instead, they found something else: black bars. Page after page of redacted names, entire paragraphs blocked out, key details hidden from public view. And almost immediately, one question started trending.
The DOJ's document dump of hundreds of thousands of pages failed to comply with the law authored by Congressman Thomas Massie and me. One document, 119 pages of grand jury testimony, was completely redacted.
So in this video, we're breaking it down clearly and carefully. What was actually released, when the court ordered portions of the Epstein-related filings to be unsealed, what followed was not a single document, but thousands of pages. These records came primarily from a civil defamation lawsuit connected to Jeffrey Epstein and Ghislaine Maxwell. Many of the documents had been sealed for years. Others were filed under pseudonyms like John Doe to protect identities while the court reviewed whether disclosure was appropriate. So what was actually inside?
Again, this is Abigail Jackson. She works in the West Wing, White House Deputy Press Secretary. She says, we did see something in these files, just not what you wanted to see, and then showed an image of former President Bill Clinton. Obviously, questions that former President Bill Clinton has to make with these new images made. And the White House is saying, look, we're giving you something. It's just maybe not what a lot of people expected.
Still, what's been made public so far falls well short of the full disclosure required by the law Congress passed last month. These new releases come in addition to the thousands of pages of photos, correspondence, and other material released on Friday afternoon. And the Justice Department says there will be much more to come in the coming weeks.
The release included sworn depositions, email exchanges, court motions, judicial orders, and exhibits submitted as part of earlier proceedings. Some filings dated back nearly a decade. Others were more recent procedural decisions about whether certain names should remain sealed. What redaction legally means. To understand why names remain blacked out, you have to understand what redaction actually is. In federal court, redaction is a standard legal practice. It means removing or obscuring specific information from a public document before it is released. This can include names, addresses, identifying details, or entire paragraphs. There are several established legal reasons why a court may redact information. First, grand jury secrecy. Under Federal Rule of Criminal Procedure 6E, matters that occur before a grand jury are protected from public disclosure. Second, the protection of alleged victims. In cases involving sexual abuse or exploitation, federal courts routinely shield victim identities.
The heavy redaction in the initial batch of files, the DOJ says it erred on the side of, quote, over-redaction to protect victims of Epstein.
Third, uncharged third parties. If someone is mentioned in testimony but has not been formally accused or charged, a court may decide that publicly revealing their name would be unfair. And finally, ongoing investigations. If releasing certain details could interfere with investigative activity, courts may keep those portions sealed. And that balancing process explains why some names were revealed while others remain hidden.
Why some names remain hidden.
Even when the Epstein-related court documents were released to the public, many names remained redacted. These blacked-out sections are not arbitrary. They follow strict legal guidelines intended to protect privacy and the integrity of ongoing investigations. The Department of Justice has consistently explained that redaction serves several purposes. They protect alleged victims from identification and potential harassment.
The Department of Justice put out a statement this morning on social media saying that some of these documents contain untrue and sensationalist claims made against President Trump that were submitted to the FBI right before the 2020 election. To be clear, the claims are unfounded and false.
A lot of people are very angry that pictures are being released of other people that really had nothing to do with Epstein, but they're in a picture with him because he was at a party, and you ruin the reputation of somebody. So a lot of people are very angry that this continues.
That they made a decision to withhold and redact information that goes beyond what is stated in the law. And just as a reminder, what is stated in the law is that there are 5 categories of information that can be redacted. That includes identifying information about the victims. And just scrolling through these documents, you can tell, there are photos where there is a black box over a woman's face. That clearly falls under that category. But there are other examples as well, like child sex abuse, anything that shows physical abuse, anything that could hurt an ongoing investigation, something that could hurt national security.
And this is just riddled with issues that the survivors are pointing out, that it's filled with their names, personal information, and in some cases, their names are not redacted, and the potential perpetrators' names
that's it.
Are
That's exactly
redacted.
right. Like too many redactions for these these people who are accused of abuse.
Right, and so that's what's making the survivors so frustrated. The statement that we have from one of the attorneys says for 5 days, the Department of Justice has left the survivors of Jeffrey Epstein publicly exposed, named, and personally identified on the government's own website, despite acknowledging that these disclosures were wrongful and agreeing to correct them immediately.
The transparency debate. Even with legal explanations in place, the redactions have sparked intense debate. For many observers, the Epstein case represents more than a criminal investigation. It represents a question of power, influence, and accountability. So when documents are released with names still blacked out, skepticism follows.
To put it bluntly, the way that this has been released by the Department of Justice has not been in compliance with the original intent of the law. The Epstein Transparency Act directed the Department of Justice to publish all of the files and materials related to Epstein and Ghislaine Maxwell. Flight logs, records, any grand jury testimony, all of that was supposed to be released, redactions to protect victims' names, but that was it. And anything related to ongoing investigations, that was supposed to be redacted. What we have seen is that not everything has been released all at once. Instead, we're seeing this kind of trickle out over the course of several days now. We've also seen names that have been redacted in some of these emails with no apparent reason why, between attorneys, it looks like. That's not supposed to be covered up in some of these redactions.
Law allows the Justice Department to release some of the files with redactions in specific instances with regard to victims of Jeffrey Epstein's crimes, with regard to abuse. But the amount of the redactions surprised people who were expecting to get more information than they felt they received.
Some lawmakers and public figures have argued that full transparency is necessary to maintain trust in the justice system. On one side, transparency and public interest. On the other, privacy, fairness, and the risk of reputational harm to individuals who were never formally charged. This is not a simple decision. What has not been released? Even after thousands of pages were unsealed, not everything connected to the Epstein case is public. Large portions of the court record remain under seal, and many materials are deliberately withheld from the public eye. Verified reporting from major outlets confirms that certain grand jury materials have never been released. Under Federal Rule of Criminal Procedure 6E, grand jury proceedings are confidential by law.
Attorney General Pam Bondi writes, quote, in accordance with the requirements of the Epstein Files Transparency Act, and as described in various department submissions to the courts of the Southern District of New York assigned to the Epstein and Maxwell prosecutions and related orders, the department released all records, documents, communications, and investigative materials in the possession of the department that relate to any of 9 different categories. That was possession. It's early off. You may remember that 2 weeks ago, the DOJ released more than 3 million pages of documents in what it claimed was its final release, even though they admitted to having nearly 3 million more pages that they held back.
The Epstein document release answered some questions, but also highlighted limits. Transparency exists in the U.S. legal system, yet privacy and due process are equally protected. Being maimed in a filing does not imply wrongdoing. Courts balance public interest with legal obligations. carefully deciding what can be seen and what must remain hidden. Don't forget to like the video, subscribe to the channel, and turn on notifications so you're always first to see our latest uploads.